Hi, I'm John Ouellette. I am an assistant professor at Middle Tennessee State University, and I'm an entertainment attorney. The paper I'm presenting today is how record labels and music publishers deal with copyright issues. In this paper, we'll take a quick look at the termination process. We'll discuss challenges faced by songwriters and artists when trying to prepare or have somebody else prepare for them and a valid termination of transfer notice. We'll look at how record labels and music publishers deal with termination of transfer. And then we'll discuss some changes with regard to policies for copyright registrations and indemnification provisions that are included in songwriter agreements and recording artist agreements. First, let's just take a quick overview of the termination process. As I'm sure you know, the Section 203 of the Copyright Act applies to grants executed by the author on or after January 1st, 1978. And we'll just talk about termination in the context of Section 203. The effective date of termination has to happen within a 5-year period that opens up or begins either 35 years from the execution of the grant, or if the grant includes the right of publication, which of course songwriter agreements and recording contracts do, then that 5-year period begins either 35 years from the date of publication or 40 years from the execution of the grant. This is one area that can trip up songwriters and artists when they're trying to prepare a valid termination of transfer notice. That termination notice has to identify certain things. One of the things it should identify is the grant. This is another area that creates problems for songwriters and artists, and we'll talk about that in a little bit. Does the songwriter have a copy of the grant? How are you going to identify the grant if the songwriter can't provide you with a copy of it? Does the artist have a copy of the grant? Probably not in both cases. And in my experience, if the songwriter, and I've only dealt with songwriters, but if the songwriter has a copy of the grant, it's in storage and you're not going to get it from them. Does the songwriter know when the song was written and delivered to the publisher? The date of creation is important. Does the artist know when the master was recorded? The reason the date of creation is important is because we have these contracts that are going to span several years, and obviously the songwriters and the artists are going to be delivering works over a course of many years in many cases. The date of the execution of the contract, the exclusive songwriter agreement or the exclusive artist agreement, is not what we base the calculation off of to know when the 5-year period begins and ends. It's the date of creation of the work. So if they don't know when the song was created, if they don't know when the master was recorded, how can you start doing the math to calculate the time period? If you can't identify the grant and you can't accurately calculate when that 5-year period begins and ends, you could easily have an invalid termination or transfer notice. Let's talk about how the record labels deal with termination or transfer notices. I've talked to several people at different record labels, all who requested that I not name them, but they all basically told me the same thing. They get a termination of transfer notice and they're going to object immediately. They object because the sound recording, in their opinion, is a work made for hire. Once they object to the notice, they start negotiating to try to retain some rights, maybe offer the artist a better deal, more money, whatever the case may be. But they're going to object right out of the gate. And if there are any flaws in the notice, maybe the 5-year period has been miscalculated, the effective date of termination doesn't fall within the correct time frame, they're going to object on that basis as well. But they're going to object and claim that the work is a work made for hire, which of course is not eligible for termination of transfer. Whether or not sound recordings are work made for hire, who knows? Most of these cases, when an artist files a termination transfer notice, they're just settled behind closed doors. No one even hears about them. There aren't lawsuits filed. there's just a negotiation that takes place. There have been some lawsuits that are filed, and so far they've all settled out of court. Dwight Yoakam had sued Warner Music Group and recently settled back in February of 2022. Still pending out there are the Waite v. UMG recordings and the Johansson versus Sony Music Entertainment cases. These are class action cases, but trying to litigate the same issue. Is the sound recording a work for hire? And if it's not, then it's eligible for termination and transfer. Those cases have just been kind of pending for a while, and there aren't really any new developments going on there. So we'll have to wait and see if they actually go to court and we have a trial and we have a court render an opinion as to whether sound recordings are a work made for hire. And I, for one, can't wait until we get that answer, because I'd just like to know. But I don't expect we're going to get one anytime soon. Let's talk about how music publishers deal with termination and transfer. It's a little bit different for a music publisher because they don't have that it's a work made for hire argument, at least not in very many cases. Really, the only time you ever see a song as a work made for hire is when it's written specifically for a movie or a television program or some other audiovisual work. As I'm sure you know, the typical songwriter, music publisher arrangement is not set up as a work made for hire. So the music publisher receives the termination or transfer notice. They're going to examine it, make sure it's not flawed in any way that could be fatal to the notice. And if it's not, then they're going to look at the income history. If the songs that are subject to this termination or transfer notice are making a lot of money for the music publisher, and they see the potential for lots of new uses in the future and the ability to continue to generate money from those works, the publisher is going to start to negotiate to try to keep the rights. If, on the other hand, the publisher looks at the income and there really isn't much there, then they're going to spend their energy somewhere else, spend their resources somewhere else, because obviously if they're trying to keep the rights, they're going to have to negotiate some kind of a better deal for the songwriter, maybe pay them some actual cash, either recoupable or not, but it's going to take some resources for the publisher to keep those rights. And if the songs aren't making any money and there's no real prospect for them to be making money in the future, it's probably not worth it for the publisher to go after it, and they'll just let them go. But in many cases, they're negotiating to try to keep the songs. So there's a new development with regard to copyright registrations that frankly floored me when I heard it. I've talked to several music publishers, and not all of them are doing this, but some are now only registering songs that are important. I don't know how you determine whether a song is important. And I asked them that, and they essentially said that they just look at the release and try to, estimate whether they think that release is going to have any real success. And part of the issue is just kind of the reality of the world we live in now with social media and streaming. It is so easy for people to put music out, but there's not maybe any marketing money behind it. And, maybe the publisher's thinking, well, that's not really going to go anywhere, so we're not going to worry about it because it costs money to register the copyright, as I'm sure you know. And on top of that, it's resources, it's manpower and things like that the publisher has to put into it. One thing that was consistent with all of the publishers is they all told me that it is really difficult in the music industry today to track all of the new uses of their songs. Now, not all of those would be anything that would need to register the work because it's just that initial publication, of course, but it's just hard to track all the uses. And they do think that there are some new uses of songs, first publications, where they don't even know about it. It's going out and it's hard to keep track of because, again, Anybody can record something and put it on social media. Anybody can record a song and put it on all of the streaming platforms. And it's hard for them to track all of this stuff. But there are a handful of publishers who are now saying, registration is only for the songs we deem worthy, the songs we deem to be important enough. So they're not registering everything. I worked in publishing for a long time, and we registered every song, or at least tried to register every song, within 3 months of the initial publication. And there are good reasons to register works. There are lots of benefits to registering your copyright. One is you cannot file a copyright infringement lawsuit without having a certificate. I'm sure you know that. Now, you could wait and register, after you hear about the infringement and you need to file a lawsuit. But at that point, now you're scrambling to get the registration done. You might have to pay the extra $800 for special handling at the Copyright Office. And then you've also essentially waived other rights, like the eligibility for statutory damages and attorney's fees, where if you register prior to the infringement or within 3 months of initial publication, you're eligible for statutory damages and attorney's fees. If you don't, you're not. There's also the rebuttable presumption of validity. If you register within 5 years of initial publication, you have that presumption. It's rebuttable, but you have it. And then under the compulsory license, while you don't have to register the work to get paid, if the copyright owner's information can't be found in the Copyright Office, they're not entitled to any royalties. The user doesn't have to pay them. I would suggest that one really good way to make sure your information as a publisher, as a copyright owner, can be found in the Copyright Office website or in the Copyright Office records is to register the work. And then there's the effect on recorded documents. Anybody who is trying to perfect a chain of title or perfect a security interest is going to want to record the document that gave them the rights or the security interest. And that perfection only happens if those works are registered. So during the due diligence process, they're going to be looking to see if at least the songs that are making money, that they're registered with the Copyright Office. And if they're not, then the seller or the borrower, whatever the case may be, is going to have to scramble to get all the registrations filed. And at that point, who knows, maybe the rate's gone up to $100 a song or something like that. So it could cost a lot more money, and it's going to be a bigger headache if you wait. So I always encourage people to register as promptly as possible after publication. But there are some people who are just, for certain songs, they're not even registering them at all. Lastly, we'll talk about indemnification provisions in songwriter agreements and artist agreements. I've been doing this for a long time. I don't really like to talk about how long because it makes my joints ache when I say how long I've been doing this. But when I started, I was in-house at a publishing company, and lawyers for songwriters would always ask us to have the indemnification liability only apply if the claim resulted in a final adverse judgment or was settled with the songwriter's consent. We always refused to grant this. I was talking to a lawyer, doing a deal, and he told me that publishers are doing this now and record labels are doing it, and I didn't believe him, so I started making some phone calls. And as it turns out, there are publishers and record labels doing this. And for the songwriter or the artist, this can be a tremendous benefit. If you're famous, if you are successful, you will most likely get sued. Many of these lawsuits are frivolous, and they either are dropped if someone chooses to fight them, or they lose, they being the plaintiff that's suing. So in that case, if the indemnification liability only applies to final adverse judgments or settlements, it wasn't settled, it wasn't an adverse judgment, then the record label or the publisher, whichever the case may be, is on the hook for all the legal fees. The artist and the songwriter don't have to worry about it. So it could be a huge win, in a way, for songwriters and artists in the event there's ever that kind of frivolous claim. And that wraps up my presentation, and I thank you for watching.